Hello friends, I am Anupma Goyal, Coordinator of Advanced Constitutional Law Modules under UGC E-Pathshala project, speaking for Dr. Rashmi Nagpal, who has written module on Fundamental Freedoms and Reasonable Restrictions under Article 19. To start with, learning outcome. After going through this module, we shall be able to learn that if people were given complete and absolute liberty without any social control, the result would have been chaotic. Absolute individual rights cannot be guaranteed by any modern state, as an organized society is the precondition of civil liberties. 6 freedoms mentioned under Article 19 are, however, not absolute. To introduce the topic, Articles 19 to 22 of the Indian Constitution are mentioned as right to freedom. Articles 19, 20, 21 and 22 deal with the different aspects of freedoms, the basic rights of a citizen in a democracy. Articles 19 to 22 of the Constitution are grouped together under the heading Right to Freedom. The rights enumerated under this article are the natural capacities of an individual, and the Constitution merely guarantees them to every citizen, which are subjected to certain limitations. Each one of us has the freedom in the matter of use and exercise of these capacities. Certain specific freedoms are guaranteed under Article 19, which can be subjected to reasonable restrictions by law. Clauses 2 to 6 of Article 19 recognize the power of the state to make laws imposing reasonable restrictions for the reasons set out in them. Also, the rights guaranteed under Article 19 are available only to the citizens of India, while the rights guaranteed under Articles 20, 21 and 22 are available to all persons. Now, we will discuss the detail of Article 19. Article 19(1) mentions that all citizens shall have the right to 19(1)(a) freedom of speech and expression, 19(1)(b) to assemble peaceably and without arms, Article 19(1)(c) to form associations or unions, 19(1) subclause d to move freely throughout the territory of India, 19(1)(e) to reside and settle in any part of the territory of India, Article 19(1) clause f, which used to be the right to acquire, hold and dispose of property, was omitted by Constitution 44th Amendment Act passed in 1978. Article 19(1) clause g is pertaining to practice any profession or to carry on any occupation, trade or business. Now, we will discuss all these freedoms one by one. To start with, the first freedom given under Article 19(1)(a), that is freedom of speech and expression. Meaning and scope of this freedom, like freedom of speech and expression, is indispensable in a democracy. This means that the right to express one's own convictions and opinions freely by writing, printing, a word of mouth, pictures or any other mode. The expression connotes also publication, and thus freedom of press is also included in this category. In all, the fundamental principle involved here is the people's right to know. As of now, there are 8 restrictions on this freedom of speech and expression. Freedom of speech and expression, therefore, under Article 19(1)(a) of the Constitution provides freedom of speech, which is the right to express one's opinion freely without any fear through oral, written, electronic medium, broadcasting or even by press. The Constitution does not, however, make any special or specific reference to the freedom of press. In Ramesh Thapar versus State of Madras, decided in 1950 by Supreme Court of India, the Supreme Court held that the freedom of speech and of the press, laid at the foundation of all democratic organizations, for without free political discussion, no public education, so essential for the proper functioning of the process of popular government is possible. In Menka Gandhi versus Union of India, decided in 1978, Supreme Court said that freedom of speech and expression has no geographical limitations and it carries with it the right of a citizen to gather information and to exchange thoughts with other, not only in India but abroad also. One-sided information, disinformation, misinformation and non-information all equally create an uninformed citizenry which makes democracy a farce. Freedom of speech and expression includes, therefore, right to impart and receive information, which includes freedom to hold opinions also. This was categorically held in Union of India versus Association for Democratic Reforms, decided by Supreme Court of India in 2002. There are various restrictions also given under Article 19(2). Security of state, friendly relations with foreign states, public order, decency, morality, defamation, contempt of court, incitement to an offence and sovereignty and integrity of India. So, therefore, there can be reasonable restrictions imposed on this freedom of speech and expression, but then also there is a right to have this freedom is available, which includes the right to information, for which Right to Information Act has also been enacted in 2005, the object of which is to promote openness, transparency, accountability in administration. Under Article 19, Clause B, freedom of assembly has been provided. The right to assembly is implied in the very idea of democratic government. Article 19(1)(b) guarantees to all citizens of India right to assemble peaceably without arms. This includes the right to hold meetings and also to take out processions. But the assembly must be peaceful and it has to be unarmed. If an assembly becomes unlawful, it can be ordered to be dispersed. Under section 129 of Criminal Procedure Code, if the disturbance to the public peace is reasonably apprehended and it becomes an offence not to disperse after a lawful command to disperse is given. Under section 141 of Indian Penal Code, an assembly of 5 or more persons become an unlawful assembly if the common object of the persons composing that assembly is to resist the execution of any law or legal process, to commit any mischief or criminal trespass, or obtaining possession of any property by force, or to compel a person to do what he is not legally bound to do, or omit which he is legally entitled to do, and also to overawe government by means of criminal force or show of force, or any public servant in exercise of his lawful powers. So, this is a right to assembly which is there under 19(1)(b), but it is again along with some reasonable restrictions imposed under Article 19 Clause 3, which are in the interest of sovereignty and integrity of India, which was added by the 16th Amendment Act 1963 and also on the grounds of public order. Article 19(1)(c) guarantees to all its citizens the right to form associations or unions or cooperative societies. The cooperative societies addition was done by the Constitution 93rd Amendment Act in 2011. The right to association presupposes organization. It is an organization or permanent relationship between its members to have a common concern. It thus includes a right to form companies, societies, partnerships, trade unions, and even political parties. The right guaranteed is not merely the right to form association, but also to continue with the association as such. The freedom to form association also implies the freedom to form, to join, and even not to join an association or union. The right of association, like other individual freedoms, is not unrestricted. Article 19, Clause 4 empowers the state to impose reasonable restrictions on the right to freedom of association and union in the interest of public order, morality, and sovereignty and integrity of India, again which was added by the 16th Amendment Act of 1963. The Criminal Law Amendment Act 1908, as amended by Madras Act 1950, provides that if the state government is of the opinion that any association interferes with the administration of law or with the maintenance of law and order, or that it constitutes a danger to the public peace, it may, by notification in the official gazette, declare such association to be unlawful. The validity of above act was challenged in the case of State of Madras versus V.G. Rao in 1952. The Supreme Court held that the restrictions imposed by section 16(2) clause B of the Act were unreasonable. The test under it was subjective satisfaction of the government and the factual existence of the grounds, which was not a justiciable issue. As far as the facts of the case were concerned, the Madras government had declared the People's Education Society in Madras as an unlawful association. Under the relevant law, the government could do so if it thought that the association constituted a danger to public peace, or for that reason that it was interfering with the maintenance of law and public order, or that was its object. Therefore, the vesting of power in the government to impose reasonable restrictions on this right without allowing the grounds tested in a judicial inquiry was a strong element to be taken into consideration in judging the reasonableness of restrictions on the right to form associations or unions. The existence of advisory board could not be a substitute for judicial inquiry. Now we come to freedom of movement provided under Article 19, 1 Clause D. Article 19, 1D guarantees to all citizens of India the right to move freely throughout the territory of India. This right is, however, subject to reasonable restrictions mentioned in Clause 5 of Article 19, that is, in the interests of general public, and secondly, for the protection of interests of scheduled tribes. In A.K. Gopalan versus State of Madras, decided in 1950 by the Supreme Court of India, the Supreme Court, in context of Article 19(1)(d) said, that the emphasis was not on the right of movement simpliciter, but on the territorial breadth of that right, that the movement can be carried on throughout India without any barriers, either interstate or intrastate. Similarly, in 1950, again in N.B. Khare versus State of Delhi, the order of externment made under the East Punjab Safety Act of 1949 was challenged by the petitioner as imposing unreasonable restrictions on his right to move freely, as he was ordered by a district magistrate to remove himself immediately from Delhi district and not to return there for a period of 3 months. But Supreme Court of India held that the externment order was valid, as it was necessary at that time to prevent the person from acting in any manner which is prejudicial to public safety or maintenance of public order, as the order also fulfilled all the legal requirements and was to remain in force only for 3 months, and the grounds on which it was made had already been communicated to the externee, who was also being provided with the right to make representation before the advisory board constituted under the Act. The order was held to be constitutional and valid. According to Article 19(1) Clause E, every citizen of India has the right to reside and settle in any part of territory of India. However, under Clause 5 of Article 19, reasonable restrictions may be imposed on this right by law in the interests of general public and also for the protection of the interests of any of the scheduled tribes. The object of the clause is to remove internal barriers within India or any of its parts. The words territory of India as used in this article indicate freedom to reside anywhere and in any part of the state of India. It is to be noted that right to reside and right to move freely throughout the country are complementary and often go together. Thus, where a prostitute under the Suppression of Immoral Traffic in Women and Girls Act 1956 was ordered to remove herself from the limits of a busy city, the restriction placed on her movement and residence were held to be reasonable. Now we come to freedom of profession, occupation, trade or business provided under Article 19(1) Clause G. Article 19(1) guarantees that all citizens shall have the right to practice any profession or to carry on any occupation, trade or business. However, the right to carry on profession, trade or business is not unqualified. It can be restricted and regulated by authority of law. Thus, the state can under clause 6 of Article 19 make any law imposing reasonable restrictions on this right in the interest of general public and also for prescribing professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade or business. Secondly, the state to carry on trade or business to exclusion of citizens wholly or partially can also be another reasonable restriction. What constitutes reasonable restriction under Article 19(6)? The reasonableness of restriction has to be tested both from procedural as well as substantive aspects of law. In order to determine reasonableness of restrictions, regard must be had to the nature of business and also the conditions prevailing in the trade. In determining the infringement of the right guaranteed under Article 19(1)(g), the nature of the right alleged to have been infringed the underlying purpose of the restrictions imposed, extent and urgency of the evil sought to be remedied, the disproportion of the imposition and the prevailing conditions at the time enter into judicial verdict. In Ram Javaya versus State of Punjab in 1955, the government scheme to nationalize school textbooks was held valid under this article 19(1)(g) because the private publisher's right to print and publish any book they liked and offer the same for sale was not held to be curtailed. The choice of textbooks for the recognized schools lay with the government, and the publishers have no right to have any of their books prescribed as textbooks by the school authorities. For some time now, the trend has been undergoing a change. Instead of nationalization, the trend has shifted to privatization. Instead of government control over trade and commerce, the emphasis now is to relax governmental controls. The government has come to view its role more as a facilitator rather than a controller of the private enterprises. Res extra commercium is the doctrine which is covered under 19(1)(g). It can be seen that grounds of restriction on the rights of speech, assembly and association are written comparatively in a narrowly drawn language. But as far as clause 6 of article 19 is concerned, it has been written in the most expansive, and whatever is conducive to serve the public interest can be a valid ground for restricting the right of occupation, trade and business. There are two views in this context. One view is that which is dominant, which says that the guarantee under article 19(1)(g) does not include anti-social and noxious activities, and therefore legislation is not necessary to outlaw such activities, and enacted legislation need not to be justified under article 19 clause 6. This is known as the doctrine of res extra commercium. The opposite view is that article 19(1)(g) covers all activities which can gainfully be carried on, and from that totality quite a few have been excluded and can be further excluded in public interest. Burglary and toutism are excluded because law prohibits them. This view differs from the first mainly in this, that it does not accept the role of judiciary to prune the scope of the reach of the Constitution's language without legislative intervention. The case in which this doctrine was invoked is the Constitution Bench decision in State of Bombay versus R.M.G. Chamar Bagwala, decided in 1957. In this case, the constitutionality of the Bombay Lotteries and Prize Competition Control and Tax Act 1948 as amended in 1952 was an issue. The appellant's first contention was that the law was enacted under entry 26, that is trade and commerce within the state, and not under entry 34, which relates to betting and gambling of the state list. Another contention was that the tax which was imposed under the law was a tax levied under entry 60 of the state list, that is taxes on trade etc., and not under entry 62 of the state list, that is taxes on betting and gambling. The third contention was that betting and gambling was also trade, and thus the law was violative of article 19(1)(g), read with clauses Clause 6 of 19 and Article 301 read with Article 304 Clause B. Article 301 deals with freedom of trade, commerce and intercourse, and 304B deals with reasonable restrictions imposed in public interest on that right provided under Article 301. The court rejected all the contentions. First two contentions, the respective entities themselves make a distinction between betting and gambling on one hand and the trade and commerce on the other. Therefore, the third contention of the appellants was to the effect that in Articles 19(1)(g) and 301, the term trade was used in a wider sense so as to include every gainful or profitable activity, irrespective of the fact whether it was vicious, reprehensible, immoral or dangerous. This was not accepted by the court, and it was pointed out by the bench that our ancient scriptures, including the Vedas and the Mahabharata also, have talked about the harmful character of gambling. Also, in another case decided in 1954 by Supreme Court of India, that is in Kuvarji versus Excise Commissioner, the distinction was drawn between ordinary trade and trade of a dangerous character like that of liquor, and in later type of cases the law could even totally suppress it, prohibit it or could limit it by giving monopoly to a few and excluding others. The fundamental right to establish educational institutions as contained in Article 19(1)(g) was also discussed in number of cases by Supreme Court of India, and was held that it is also subject only to reasonable restrictions which may be imposed by any law only in terms of Clause 6 of Article 19. In P.A. Inamdar versus State of Maharashtra, decided by Supreme Court of India in 2005, it was held that the right to establish an educational institution for charity or for profit, being an occupation guaranteed to all citizens under Article 19(1)(g) and to minorities under Article 30 of the Constitution of India. Education, even though is an occupation, but cannot be equated with trade or business. Even a separate right to education under Article 21A has been provided by the 86th Amendment Act in 2002 into the Constitution, whereunder Right to Children to Free and Compulsory Education Act has also been passed in 2009, the validity of which has been recently upheld by the Supreme Court of India in 2014 in the case of Paramati Educational and Cultural Trust versus Union of India, whereby the Constitution bench has held that exclusion of minority aided and unaided educational institutions referred to in Article 30 Clause 1 from the purview of Article 15 Clause 5. Article 15(5), which was added by the 93rd Constitutional Amendment Act in 2005, is not discriminatory. They also clarified that Article 15 Clause 5 is an enabling provision to effectuate equality of opportunity and does not alter the basic structure or the framework of the Constitution, and therefore it is constitutional. Now, to conclude, Article 19 clauses A to G guarantees to the citizens of India 6 freedoms, that is of speech and expression, peaceful assembly, association, free movement, residence and practicing any profession or to carry on any business. various freedoms are necessary not only to promote basic rights of citizens, but also certain democratic values and the oneness and the unity of the country, and guarantees some of the basic valued and natural rights inherent in a person. However, the freedoms guaranteed by Article 19(1) are not absolute, as no right can be. Each of these rights is liable to be controlled, curtailed and regulated to some extent by laws made by the Parliament or by the state legislatures. Accordingly, clauses 2 to 6 of Article 19 lay down the grounds and the purposes for which a legislature can impose reasonable restrictions on the rights guaranteed by Article 19(1) A to G. Thank you.